of Monday, March 27th, 2023. It's 5 p.m. We are located in the hearing room at One Government Center in Fall River, Massachusetts. I will start with reading the open meeting law. Pursuant to the open meeting law, any person may make an audio or video recording of this public meeting or may transmit the meeting through any media. Attendees are therefore advised that such recordings or transmissions are being made, whether perceived or unperceived, by those present and are deemed acknowledged and permissible. Can we take attendance, please? Starting from my left.
Dan Rumble.
That's my right, sorry.
Oh, Paul Machado.
Tim Campos.
Rena Brown,
Kathy Nemkovich.
Laura Washington.
Tracy Almeida.
Alan Rumsey. Still no with us.
John Mitchell will be absent tonight, and Mimi Larrabee will not. Both have previously scheduled commitments. We'll open it up to public comment, please.
Pledge of Allegiance.
Oh, yeah, I'm sorry. Thank you. Pledge of Allegiance. Thanks, Kath.
Oh, it's really.
I knew there was something. I pledge allegiance to the flag of the United States of America
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everybody. We'll open it up for public comment. Mr. August, go ahead.
You want me to stay here?
I think you might need to go up there, so I think, I think we're recording, I don't know, I
Yeah,
can't
I
tell.
believe they are. Yeah.
Okay. So,
Augie Venice, 25 Wrights Way, Fall River. One of the things that I think, you all have a packet that I visually worked on today.
I gotta make the record has to reflect this. Mr. Venice came to the meeting, passed out handouts. They're not handouts previously provided to this committee. Therefore, I don't think that I don't think we're gonna violate the open meeting law because these are not handouts generated by us or provided to us until this meeting started. So we will attach these to the minutes as a public comment input document only. Thank you. Go ahead, Mr. Venice. I'm sorry to interrupt.
I'm not going to talk anymore. In the charter, there's no mention of the form of government, Plan A, form of government. Government by the mayor, city council, school committee, elected at large with preliminary elections. I would like to see some form of, something in the charter that says something that the form of government provided in these sections shall constitute and be known as a Plan A under this act. I don't know if that's still legal or not, but that's one of the things I'm recommended, that some mention that we operate under a Plan A form of government. At last meeting, there was conversation about when the president of the city council ran, or was serving as mayor, and the vice president resigned, that there was nobody available to call the council together or do what had to be done. I looked through some 25-odd charters, and the next one in your packet says, after the oath has been administered to the council's president, the city council shall call to order the city clerk on the case of his absence by the oldest senior member present. And the next thing in your package is pretty much the same. The city council shall meet annually on the first Monday in January, meet for the purpose of organization. They shall be called together by a city clerk, or in the absence of the city clerk, by the member present, senior in age and years of service, who shall preside. The city council shall then elect from its members by separate roll call votes a president and vice president. So when you have no president or vice president of the city charter, there is some precedent as to how to proceed. And apparently the city clerk will be in charge of calling a meeting of the city council, or the most senior person on the city council, and take a vote and elect the president and vice president. So that's not included anywhere within the charter provisions, so maybe that language should be included as well. One of the things that always bugged me is when candidates are appointed to certain offices. In the past, maybe 10 to 15 years ago, when somebody was nominated to an office, they showed up at the city council meeting. They said, Mr. Joe Jones was appointed. He introduced himself. He spoke a little bit about how he wanted the position or whatever. So I found language from another charter that says the municipal council shall refer all such nominations to a standing committee, which shall investigate the candidates and make a report with recommendations to the municipal council on each such candidate, not sooner than 7 or later than 28 days following such referral. If the municipal council has taken no other action, said appointment shall become effective on the 45th day following the date. So that, I'm recommending that the city council form a standing committee to review all these candidates, vet them, and then make their recommendations to the council. One of the other things that's happened a lot in the past is failure to fill vacancies. And I'm recommending language similar to what I have. When a vacancy occurs for whatever reason on a municipal multi-member board whose members are subject to city council approval, the mayor shall submit to the city council the name of the person to fill the vacancy as soon as possible. If the mayor does not submit a name within 90 days after such vacancy occurs, the city council shall submit names forthwith to the mayor, who shall select one of the names submitted or a person of his own choosing to the vacancy within 15 days. I don't know how the vacancies in multiple member bodies are now, but I remember, 10, 15 years ago, there were multiple openings on a lot of the bodies, and nobody was in any rush to fill the vacancies. So this says that this shows a procedure as to, how to follow it. If the mayor does not submit a name within 90 days, the council shall submit names. The council shall submit names to the mayor, and the mayor shall select one of the names submitted within 15 days. The previous section 3.8, temporary absence of the mayor. I have a new proposal. The acting mayor, the mayor shall by letter file with the city council and a copy filed with the city clerk designate a qualified city officer or city employee to exercise the powers and perform the duties of the office during the temporary absence of the mayor for periods of less than 21 successive days, and to serve only when the needs of the city require and only to the extent necessary under the then existing conditions and circumstances. So I listened to Attorney Rumsey, who had some problems that, maybe the mayor could appoint somebody, on a temporary basis to fill that. And Section A of my proposal kind of takes care of that. Originally, I had 3 days, then I went up to 10, then I went up to 21. So, I guess if you accept the idea, then you can argue about the number of days. B, whenever a reason by sickness, incapacity, absence from the city, or other such cause, the mayor is temporarily unable or unavailable to perform the duties of the office for a period of 21 successive working days or more, the mayor shall notify the city clerk and city council in writing of his absence and expected duration. During such absence, the president of the city council shall be the acting mayor. If the city council president is unable or unwilling to serve as acting mayor under this section, the vice president of the city council shall serve as acting mayor. If neither the city council president or vice president is unable to serve, the city council shall then elect from among its membership a councilor to serve as acting mayor. And C, the powers of the acting mayor shall only have those powers of the mayor that are indispensable and essential to the conduct of the business of the city in an orderly and efficient manner, and in which action may not be delayed. The acting mayor shall have no authority to make permanent appointment or removal from city service unless the disability or absence of the mayor shall extend beyond 60 days, nor shall an acting mayor approve or disapprove any measures adopted by the city council unless the time within which the mayor must act would expire before the return of the mayor. During the period in which any member of the city council is serving as acting mayor, such city council shall not vote as a member of the city council. Then I have three more. Section 310, vacancy of the mayor. Whenever a permanent vacancy occurs in the office of the mayor by death, removal from the city, resignation, incapacity, or any other reason, the vacancy in the office of the mayor shall be filled as provided in Section 3-8A. If the city council president is unable or unwilling to serve, the provisions of Section 3-8C shall apply, and the councilor so elected shall serve as acting mayor under Section 3-C, shall serve until the successor is elected and qualified at the next city election. The candidate elected as mayor at the next regular city election shall be sworn to office immediately upon the certification of the results of the regular city election and serve for the remainder of the unexpired mayoral term in addition to the term of which elected. So when you have somebody filling in a temporary position, they fill out up to the next election, and the person that wins the election, you have the elections in November, and there's like a 2-month lag until January 1st when they become mayor. The new person will take over with those 2 months included in his term. He'll do those 2 months and then start his term. The acting mayor shall exercise all rights and powers of the mayor and shall be sworn to the faithful discharge of his mayoral duties. Any city councilor serving as acting mayor under this section shall not be entitled to have the words candidate for re-election printed with that councilor's name on the election ballot. Any councilor serving as a mayor under this section shall receive the compensation then in effect for the office of mayor. Section 9-12, a limitation on holding office. Unless otherwise allowed by law of this chapter, no person shall simultaneously hold more than one city office or position of employment. Should probably be compensated city position of employment. No more than one city office or compensated position of employment. This section may be waived by the mayor upon the appointment of a person to an additional office or position of employment by filing a notice of the waiver with an explanation and justification with the city clerk, copy to the city council. Such notice shall also contain the appointee's qualifications for the position as enumerated in Section 5-2 of this charter. Any hours worked in any part-time position shall not be the same or otherwise conflict with the hours worked in a full-time position, and no person shall be paid twice for the same hours worked. So there's a limitation on holding office that a person shall not hold 2 compensated positions by the city, but if there is some kind of emergency, then the mayor can waive that. So all the other language and everything may be for naught. And my favorite, Section 9-13, felony conviction. An elected official or officer or employee of the city or any department, board, commission, agency thereof who has been convicted of a state or federal felony while holding such position, or who has been convicted of a state or federal felony for misconduct in any elected or appointed public office, trust, or employment at any time held by him shall be deemed to have vacated the position. The conviction of an incumbent of any such office of a crime punishable by imprisonment shall operate to create a vacancy in the office held by him. So these are all summaries that come from other charters throughout the state and may or may not help with certain positions that we take.
Thank you, Mr. Venice.
We put a lot of hard work into that.
Any other further public comment? Seeing none, public comment is closed. We're skipping number 5. Number 6, discussion and review of the following charter sections, 3-8, temporary absence of the mayor. And it was actually 3.8A, 3.8B, and 3.8C. We discussed some of it last time, but 3.8A, acting mayor, whenever by reason of sickness or other cause, the mayor is unable to perform the duties of the office, the president of the city council shall be the acting mayor unless the president of the city council is unable or unwilling to serve. In such instance, the provisions of section 3-8C shall apply. The city council, by an affirmative vote of 7 members, shall determine whether the mayor is unable to perform the duties of the office. The vote shall be taken in public session by a roll call. I'm gonna stop after the subsections because there was some discussion, and I'm gonna go to the agenda and address some language in here. The agenda states 3.8, temporary absence of the mayor, proposed disability clause discussion. And I just want to put on the record, the phrase was used in reference to this temporary absence of the mayor due to sickness, illness, or other cause. So in no way were we fashioning another clause or amending this to address any disabilities anybody has. It was really in reference, so I would like to just take disability clause out of there and make it the proposed definition of by reason of sickness or other cause, because one of the problems with 3.8A is the ambiguity and vagueness of what other cause means. And the time frame for, and the duties of the mayor. One of the issues and one of the things that I think the council ran into during one of our mayors is that they took a vote of no confidence. They insisted that the mayor could not perform his duties due to some legal action. He was out on bail and he couldn't leave the state. And one of the things the council discussed, and I think it was challenged also in a lawsuit, was what constituted, we know what sickness is, right? But what constituted other cause? So I just want to put it on the record that disability clause was not to offend or address anything other than in the context of other cause, other circumstances that create a situation where the mayor is unable to perform his duties of the office. And I think we all had agreed to kind of work on something to work on the vagueness and the definition of those. I think that's what we were referencing last time, so.
I have 2 notes from last time in that we were gonna revisit later the disability clause draft, because we weren't
Right.
sure what it entailed.
We didn't know what to name it, we didn't know what it entailed, but we knew it was in reference to sickness and other causes for the mayor to be unable to perform his duties. So I think I used the language, and we received some input, which will go out to the committee in the next agenda, the emails, that there was some concern about the language that I used. I'll take the blame for it. And so it's only in the context of other causes that would create a situation that the mayor's unable to perform his duties, okay? So I'm gonna change, it's not a disability clause, it's gonna be proposed definition of sickness or other cause that creates a situation where the mayor cannot perform his duties. It's 20 other words
Yeah.
versus the one word,
Try incapacity.
right? I
Yeah,
feel
but-
like that's gonna cause a problem too, incapacity. So some discussion about, I mean, do we define sickness, or is sickness
Like-
all-inclusive? Is it, so here's the thing, so sickness. What if it's a sickness that's temporary? What if it's, I know, I liked the language, I think, that was proposed about 21 days, I think it was. If it's a sickness that lasts longer. What if it's a sickness, he's hospitalized, I shouldn't even say that, if the mayor is hospitalized, and then gets out, but still really can't get around, goes to like a rehab for physical therapy or something. So I don't know, and
Why, if we put sickness in, then do we have to name a bunch of things? Can't we just say, just put in a clause of, like, what it means to unable to perform duties, instead of saying sickness, health, mental health, physical health? Just strike that and just put what a clause is for that person to-
define sickness in the definition section?
I don't think you need it. I think
Just
that's what I was
sickness is
saying. Just
fine?
whether they're physically or mentally incapable of performing their job duties for a period of over X number of days. I
Yeah.
think
Yeah.
you're good.
Right, I
I
think
like
it,
that.
I think part of it was a time frame but other cause is the issue.
Yeah, but that
What's-
has to go.
Yeah.
What's other cause?
Or what-
Or do we take other cause
It
out?
just has to go.
Take
Is
it
it
out.
just illness, sickness? Because I gotta tell you, I was thinking about other cause last night, and I think if a mayor cannot leave the Commonwealth of Massachusetts, does that interfere with the performance of their duties? If a mayor is ordered by somebody not to talk to department heads, does that interfere with the performance of their duties?
Yes.
That was the issue last time, is that there was a court order that said, do not contact witnesses and don't leave the state. And witnesses on that list were city employees. So does that interfere with the performance of
Yeah,
duties?
physically, you can't physically perform all of your duties, like physically present, physically, you know what I
How
mean?
about
You,
if we add legally?
I just think something about legally, because
Yeah.
that was the problem, Alan,
Physically-
is that other cause.
physically,
legally.
physically, mentally, legally.
Right.
I think the judge said,
Well,
other cause, you guys wanna put it in?
I would say it differently. I mean, I think the problem was, because it was vague, I don't think anybody was real happy with the situation we're in, but I think that maybe I'm wrong on this, but I think that almost every lawyer who looked at that knew that the challenge to our former mayor was going to be unsuccessful.
I was hopeful.
It's extremely, extremely difficult.
Well, I thought other cause meant when you can't
Oh.
perform your duties.
Well, it's
and I-
extremely difficult to remove a democratically elected official in
I
any
don't know.
position.
I'll tell you,
No matter if there's misperformance, or you would do it differently, or,
No,
you know.
I hear you. But then I attached chapter 268A, section 25, and it says, an officer or employee of a county, I thought that included, isn't the mayor an employee of the city? Even though he's duly elected, isn't he an employee,
It's an employee.
right?
The mayor gets paid. The mayor is an employee.
I mean,
I did find the Turner case, Turner versus City of Boston,
Yeah, I saw that.
462 Mass 5/11/2012.
what's the site again?
462 Mass 5/11,
Yep,
2012.
yep.
And the Supreme Judicial Court indicated, in that case, the Turner was a city councilor, and he was convicted of extortion. Before he was sentenced, the city council voted to remove him pursuant to local rules. The SJC basically defined what a charter is. It includes the Mass Declaration of Rights and the statutes, and the SJC indicated that he could not be removed pursuant to the charter. It concluded the Constitution specifies that officers of the Commonwealth may be removed from office only by compliance with its specific impeachment provisions set out in Part 3, Chapter 1, Section 2, Article 8 of the Mass Constitution.
So they were saying that the impeachment process in the Mass Constitution would be the only way that a home rule charter could remove an elected official.
And I tried to shepherdize this case, and there were no citations. So I think that's the last case that dealt with something like this.
So what was your recommendation then after reading that?
I don't think the mayor can be removed pursuant to the charter.
Can the charter, so, well then, if the charter put the same impeachment language in it, is it just that a home rule charter doesn't have the authority and only the state constitution has the authority? If our home rule charter incorporated the impeachment language in the Constitution, then they couldn't declare it unconstitutional because it's in the Constitution. Right? If the Turner case is saying, listen, you can't remove him because your home rule charter doesn't have a provision, and you can only remove him because the state constitution has an impeachment provision, what if the home rule charter had an impeachment provision? Then the court would have said, you know what? Your impeachment provision is constitutional according to the Mass Constitution. Out he goes. Like, that was one of the things I thought this charter needed, was an impeachment provision. And there's impeachment provisions, I think Dartmouth has an impeachment provision.
Can
It's a
that
question,
provision
kinda.
It
be
does
stronger?
kind of, yeah, because it
Can
says, oh, go ahead.
Can that provision be stronger than the state constitution?
I
Can
don't
it?
think so. It seems to be
Because
that the
when
mass.
would you need an impeachment
Impeachment?
provision if it can't be stronger, or the provision can't provide for additional ways or alternate ways to remove an official? Then why would you have one if it would defer then to the, right?
I think no matter what, the constitution, the state constitution is gonna supersede.
Is gonna supersede.
So we
State
could-
law
we
and the
could put it in,
Constitution
but
will
it's-
supersede.
Well,
But-
very simply, if the current provision to remove the mayor that took place a few years back, obviously the court said that wasn't
Well-
allowable. But I think that a simple provision that impeachment pursuant
To
to the statute and the
of the
Declaration
national
of Rights would have to
Yeah.
take place. I don't know what the impeachment procedures are under, what is it,
I don't know.
Chapter
I-
43?
Oh, I don't have my phone, I'm sorry. I looked it up too, because the state constitution calls for a provision that you can remove an elected official. And
I,
it didn't lay out the procedure specifically, it just said, you know,
I mean, you can create any sympathetic fact pattern where you probably want to get rid of the mayor. But the reality is that the courts are going to be, they're really not going to allow it unless it's pursuant to, it's going to be extremely hard to impeach or remove an elected official, as it probably should be, because if you think about it, you know, you talk about it being a blood sport. You know, it could be as something as simple as, and I'm just making this up, there's no reality to this. The mayor appoints a chief of police, or it removes the chief of police and put the new chief of police in place. All of a sudden, the mayor gets arrested. And then you have 9 politicians deciding the fate of another elected official. You know, and I'm not saying every member of the city council wants to be mayor, but you have the 9 people who most people guess were most likely to take over the mayor's position. It's just wrought with problems, and the courts are not going to allow it. They're just, it's
The
going to be
court-
extremely difficult
the
to
court
ever
didn't
remove a
say we
mayor.
couldn't remove him. The court said, your charter is vague. It doesn't say anything in there about other cause. That's what the court said in our last lawsuits, somewhat. Said, yeah, you can't do it, it's not in there.
I think most people just,
No.
in my
that was-
world,
that was
everybody
the
who said,
recall.
you're not going to have 7 politicians decide the fate of an elected official.
Yeah, no, Rena, the
Right, the recall,
recall
right.
was,
Right.
it's just not
Right.
in the charter. the city council removal or attempt to remove the mayor, the court, and I have the decision
Yeah.
here. The court indicated that, he talked about the city council lacking that power.
Right.
So what I might suggest is that, I would volunteer to do some further research on impeachment provisions. And we'll see what the statutes and the Declaration of Rights say, if anything, about impeachment provisions. And I'm
I'll
going
take on the
to,
Constitution part. I'll look up at the Constitution.
and I'm going to suggest that if they exist, I would expect that there would be a procedure that requires evidence. I mean, it's a formal procedure. You can't just take a vote, and say, mayor can't do his job, we take a vote. It would mean that there would have to be evidence
Almost
taken.
like a court hearing.
Yeah,
And my guess is you're not gonna find the ability to impeach. You may find the legal authority to act on behalf of a mayor who is incapacitated temporarily, where they still remain mayor, but somebody else gets the power to make decisions because they're in a coma or something along those lines. I mean, that's
Well,
what I
that's-
imagine we'll find.
Danny, you were gonna say something.
Yeah, thank you. Frankly, there is, whether we like it or not right now, there is a provision in a whole section, section 8-5, that talks about a recall. That's how we recall a mayor. In my mind, there needs to be changes. We have some changes here tonight that we'd like to bring forth. But that is the principal way, in my mind, that a mayor should be removed from office. Not by a vote of 7 members of the city council, not on a whim because they don't like the way he combs his hair, whatever. There's a specific policy and procedure by which you remove a mayor. That's the way it should be done. If there are so-called impeachment proceedings, I'm happy to look at that. When Sackett, Rhode Island just impeached their mayor, okay? But that's a different state, a different time. Right now, for this document, in general, we have a recall provision. Do I like every part of it? No. But that is, in my mind, the surest and cleanest way of getting rid of a mayor. I never think, and I think that provision in this charter should be completely struck based on the fact that the court struck it down, that the city council does not have the authority to take a vote to remove the mayor. They just don't. They'd like to have it, and again, that's where it becomes political. We have a provision in this document that needs refining, but there is a clear provision and a clear process for removing a mayor. That's the way we should follow it, using that as the foundation. Thank you very much. I yield.
I do tend to agree with Mr. Robillard. After I read the Turner decision, and I couldn't find any further cases, I think it's clear the SJC said the city council doesn't have that authority pursuant to the charter. But I wouldn't move to remove that until I do some further research concerning what impeachment provisions actually exist. So I would move that we defer this, come back to it at a later point so that we can
We'll come
do
back,
some
we'll come back to the
impeachment.
constitutional
Yeah.
issue of impeachment, but 3.8A we can fix. I mean, I'm
Well,
sorry, go
I
ahead.
wanted to just take a different perspective. Like the way I read this, I mean, we're kind of going at what happened, but I'm reading this as more of like the mayor's sick or disabled or not necessarily that he's in legal trouble and other cause. Like, you know, I think we're getting bogged down with a recall and all that, which maybe, as Dan was saying, is in somewhere else
Is
that we need to.
someplace else,
I
right?
think we need to make this more about if the mayor is unable, not because he's incarcerated or something like that, that's a different situation. But, how do we handle a mayor who's in a car accident or has a disability or has become, really ill for a longer period of time and is just not able to do his or her duties? And maybe we're getting hung up on that other cause word, which we talked about to start. I don't know, I'm just taking a different perspective in it, because I know there's some other parts in this charter that are gonna require us to look at what happened with our other mayor, and have to make some changes to that. So I do think we should continue looking at the charter and things, but I don't know if a mayor is sick and incapacitated, what's the process to getting a temporary mayor? And I think that's what this affirmative vote of the council was for, not to say that we're gonna recall a mayor.
No, they were that vote.
No, that vote.
That night, that vote was to remove
Right,
him.
right.
Because they wanted him to resign.
Right.
He refused to resign, so they decided in their infinite wisdom that they were gonna take a vote to attempt to remove him.
Right.
Which failed, was challenged, and was thrown out by the court.
Right.
The city council, as a legislative body, does not and should not have the singular power by a vote of that esteemed body to remove the mayor from office.
Okay.
Period.
So section 3-8, temporary absence of the mayor, section A. I make a motion that we just put a time frame in there, because maybe we just leave the language. Whenever by reason of sickness or other cause, the mayor is unable to perform the duties of the office for a period exceeding 21 days. I'm looking at it. We had already voted to take unwilling out, so that's already out.
Right.
Yeah, I like 21 days.
I mean, I like 21 days too, because then, if he's sick, I don't like other cause either. You wanna leave it, leave it. It doesn't matter to me either way.
Well, could we just tighten it and say something that like prevents him from performing his?
Unable to perform duties for a period more than 21 days.
That
Whenever
addresses
by
then
reason of
the
sickness-
issue of not being able to talk to.
Yeah.
It's still somewhat ambiguous.
Yeah,
Either-
are we talking
either
health?
language-
Is that what
It
this?
doesn't matter. I don't think it, sorry, it's not my turn, but.
No, I hear you. Maybe
Well, I
that's
think we
all
just
they
have
mean
to.
is health.
Yeah, I think we have to define what this is.
Other causes?
the other
So
causes
maybe, maybe you define other cause in the definition at a later date, and we come up with other causes. Like, maybe it stays how it is.
Yeah.
And in the definition section, other cause, and you define it. Car accident, coma, I don't know. I mean,
When you start
I'm pretty
defining-
sure
Yeah,
if
but
you're
I
on a
don't
car
think-
accident and you're in a coma, you can't perform duties in there. I mean, maybe we list, and then in the definition clause, we put, we define what other cause means. But for this particular thing, I think after perform the duties, for a period no longer than 21 days definitely has to go in here. You know what I mean?
And
Yeah.
there's somewhere that lists all of the obligations and duties of the mayor, right? There's a place where that exists, that language somewhere.
Isn't it in the ordinances what the mayor's duties
So
are?
couldn't we refer to that here and say, any other cause that prevents the mayor from meeting the obligations as outlined in X, Y, Z?
Right.
Yes.
Then we cover, if we start listing the potential issues, we're gonna leave one out. As soon as you define, you exclude,
Yeah.
right? So by not defining, it's less ambiguous, and you're pointing to the obligations, then a court would need to go to that outline of duties and make sure that the mayor can perform all of the outlined duties in that place. So that
like
might be
that.
the safest
Well-
way to go.
You know what, this is different than the removal
Right.
procedure.
This is just
Right.
temporary
And-
absence.
And I interpret that to mean that, the mayor's wife has called the city clerk and said, mayor was in an accident, he's not gonna be in to work for,
A while.
for a while.
Yeah,
Um,
that's the way I
so
interpreted it too.
I interpret that to mean that the mayor is saying, I can't come in for a while.
Right.
And then the temporary provisions apply.
But when there is no person to report and the mayor cannot report,
There's always a person.
Right.
so this
Well, I
would
don't-
cover that.
I don't think that's a bad thing, no matter what, whether it's you know, for,
And under
There's
any
always a chain of
conditions,
command, though.
Yeah.
that language
We're
protects.
getting by.
well, just a reference
The
point to say he
appointed-
was
Yeah, I
unable,
like
he or
that.
she was
Right,
unable
but I
to do
mean,
that.
and, you know, quite frankly, it says the city council by the affirmative vote of 7 members shall determine. So if the wife calls and says he's in an accident, we don't know when he's gonna be better, then the 21 days goes by, right? 21 days, if we put 21 days in here, the 21 days goes by, city council says, yep, he's still out, and then the rest of that process goes forward, because then it goes on, because it says, the provisions of 3.83, 38C are gonna apply, but I think for temporary absence, there's no time frame.
Right.
And I always thought that was like the ambiguous part of it, because 38C then refers you to, the succession. We know that it's the president, and and we took out unwilling, but if he's unable, then it goes on, and then, and then 310 addresses, okay, he got this accident, he's never gonna get better, there's gonna be a vacancy, well, then you go to 310 anyways, right?
Right.
Yeah.
This
Al-
would just be the temporary.
Temporary.
How about though, right here, because it says, so whether shall determine whether the mayor is unable to perform the duties of the office, then add in as specified in wherever that is.
Right.
And that's how they determine.
When the mayor, him or herself cannot determine it.
Yeah, where are the duties of the office, Alan? Where's the
it's in section
mayor
2.
handbook?
I think it's in the ordinances, but
I know it's in
No,
ordinance.
it's just-
Hearing 101.
I
This,
just don't think it can be the city council who determines it. Aside from the political aspect of it,
we're
they're
only
also.
talking, we're only
I know,
talking
but
temporary absence.
I
We're
get it, but
talking
even
like,
that-
if he's in a
Yeah.
coma.
They're not the ones who work with the mayor on a daily basis. They're not the ones who would even know whether or not the mayor has any kind of issue, unless it's 100% voluntary stepping aside because of a health issue. And it won't always be voluntary.
What happens now under those conditions? So the mayor is unable to perform the duties of the office for whatever reason, and it's temporary, and say it's due to sickness. What is the protocol currently today as it stands?
If he doesn't resign, and if he does not resign, right,
Why would he-
then they'd have to recall him.
Why would he resign for?
Well,
If he's sick and can't perform his duties.
we've
But
never
it's-
had this, but I
If they don't have
imagine
an
it's-
affirmative vote,
I imagine the only way to do it on an involuntary basis is similar, with the head of a corporation or an estate planning situation, which I've never been a part of, so I'm not suggesting I know. But there are ways to have a court of competent jurisdiction, judge that somebody's mentally incapable of performing and they remove them.
Think we
It's
get
not an easy
way
process,
out
but
of
it shouldn't be an easy process, frankly.
We're getting
Alan?
way bogged down.
Can I ask Alan a question?
yeah, good.
What is, how long do you think the city administrator can cover for the duties of the mayor?
It's probably, I mean, in one sense, I mean, some city administrators have done most of the work. It's dependent upon the mayor. I mean, I wouldn't say it's the case right now.
Well, they can't
But-
do appointments, not even according to this charter. Anybody acting as mayor can't make permanent appointments, so it can't be for long,
Right,
because
but
if you
the
lose your
duties of the city
department head,
administrator,
if
by
you lose your
definition-
chief, they can't appoint him.
By definition, the duties of the city administrator are as vast or as minimal as given by the mayor.
He cannot appoint department heads, I don't care. I don't care what
Hire
you
a
say,
fire.
this charter says,
I understand
it
that.
gives you duties for, when you fill in when you are the temporary mayor, there is stuff you can't do.
I understand
You
that.
lose your
I'm
police
not
chief,
disagreeing.
you're not getting another one until you get another mayor.
Madam Chair, I think, correct me if I'm wrong, Paul, I think Mr. Machado and Mr. Rumsey are trying to figure out the day-to-day running of the city, not appointments of a police chief, not appointments to a board. There's a provision in this charter, I believe, where it says after 60 days that an acting mayor can make certain appointments. So we're getting very bogged down here again on language and words and trying to look at every little situation that might occur. Frankly, the city administrator, in some cases, I don't know about Mayor Coogan, but, and I don't presume to speak for any mayor or anybody else other than myself, but Corporation Counsel Rumsey is absolutely correct. The level of authority that any city administrator receives is solely 1,000% at the discretion of that mayor. And in a case like this, I really do think there's a provision, and I'm going from memory right now, that after 60 days, an acting mayor can make some appointments. But I think we're getting very much bogged down. I think 21 or 30 days, let's go. There's bigger things than this to be discussed.
I certainly take offense to you saying we're getting bogged down.
Oh, we
And
are.
with all due respect,
Oh.
it's a committee, and everybody has opinions, and they have comments, and if they want to dissect it, everybody should be free to comment in any
Absolutely.
manner they
But
want.
plan to meet 10 more times.
And if that's what happens, then that's what happens.
Beautiful, I'm
But
all
please
for it.
don't stifle anybody
I'm not.
from being able to
Let-
comment on any portion of this,
Listen,
Dan.
Madam Chair, I am the last person in the universe that would ever stifle debate. I'm just saying, I think we're getting off track. We're making it more complicated than it has to be. That's all I'm saying.
Well,
You-
if people
you wanna
have
30
questions, they wanna
meetings
ask questions,
For
Dan.
$5 apiece, I'm all for it.
Dan, people have questions, people have comments. And whether it's off track, on track, left field, right field,
Debate it all night. I'm just saying.
right?
So Rena, did you make a motion concerning 3.8?
Yeah, to add 21 days after, whenever by reason of sickness or other cause, the mayor is unable to perform the duties of the office
Second that motion.
for 21 days, or some language like that. I mean, I don't have the exact language,
Okay.
but you know what
I
I
have it
mean.
listed as duties of the
You
officer
just
period
want the
21 days.
number, correct, ma'am?
I just want the number.
Yeah, 21 days.
Well,
My
21 days.
my problem had always been like, it's so open-ended that
Yeah, how long
I thought
is
we
that?
needed a,
Yeah, I think that's fair.
I'll second your motion. How's that? I do have a question.
yes, go
Can I
ahead.
say it? You
Yeah,
want a motion on the table?
Yeah, I think you can.
All right.
There's been a motion and a second, so.
I can discussion that. I go back to Attorney Rumsey with other causes that you think that we should strike that other causes. And I don't think that we should leave that out there. I mean, it's not like this, we have not had issues with that clause before. We've had issues
I
with
just-
that language.
Right, I just think that we can define other cause
So
in the
that's
definition
so
section.
then, and we
How about
can,
any
like-
cause?
well, I
Any
think
cause
that,
and then go to the provisions.
so, just as long as there's gonna be some definition.
I definitely
on it.
think defining terms in
Do you
here has
wanna
always been a
say,
problem,
like,
like
as
our
defined?
definition section is not good enough, but I just think that instead of defining it there, you define it in the definitions.
Quick discussion. I think the easier way to look at this is, one, I would remove other calls. But if we would look at this clause as a whole and realize that this is just it's not really a succession plan, but you know what I mean? When the mayor agrees on a voluntary basis, it's easy. So if we take out the city council part, we can be, by reason 21 days and not worry about defining anything. Because this is
then the
something.
city council doesn't have to decide if you can't perform your duties.
Right, so if we look at it as something that the mayor agrees, yes, this is where it goes, we don't have to get bogged down in the details. But let's not look at 3.8A as a way to challenge the authority of the mayor.
Correct,
Not to
correct,
remove him.
Right.
right.
And I agree with Dan when he said we're gonna deal with removal later on in
I
recall.
agree with that.
So we can strike,
I do just want to ask though, what happens if there's an illness and they can't perform their duties, but
And they can't
when the
voluntarily.
21st day comes, then we go to the succession clauses.
Yeah.
Right? Because that's what it says.
At least there's a procedure.
You know,
here
if there's
on-
21 days and the president of city council shall be the acting mayor unless the president is unable to serve in such instance the provisions of 3(8)(c). So, and the other ones talk about how long the president stays there and then the new election and all that. But I agree with you. I think that city council by the affirmative vote should come out.
Yeah.
Well, it would just automatically roll to secession, right, after 21 days?
I think so.
I mean, if you're
I mean,
incapacitated for 21 days.
Can I ask a clarifying question
Yeah.
around what you just said? Do they have to wait the 21 days, or is it when the mayor says, I cannot perform the duties? Do
Up
they
until,
have
yeah.
to, do they only wait the 21 days in the case where the mayor cannot,
Or will not.
Or has not said.
right,
Yeah.
is unable or unwilling? That's where unwilling
Never
would be too.
happened, so.
So,
Well, let's not wait till it does.
so the 21
Well, because we're
days-
gonna go to 310 and talk about vacancy in the office, and I think that's where it comes
Yeah.
in, right? So this is the temporary.
So there's gonna always be a 21-day period, no matter what, that
Even
there'll be a.
if the mayor on the first day says he or she can't perform, you have to wait 21 days?
No, could we say up?
That's what I'm looking for clarity on, because that doesn't seem
Right.
clear, and a lot of the language, the part of the problem with the whole charter is some of the vague language, so.
Right.
We're getting down,
No,
down
I hear you.
those
I
things
thought-
because it's important, it's too vague.
I put 21 days because a mayor gets the measles is enough, and he's out for 2 weeks.
Well, the 21 days,
Right,
I
I
don't
mean,
think.
but 21 days is a
I think that's
pretty
a good number.
significant illness. I mean, you're
Yeah.
talking
Yeah.
3
Yeah.
weeks
Right.
of being able to perform the duties. We are assuming it's an illness that is really incapacitating, right?
But what
Um,
constitutes, like, if, let's say he was in a, he or she was in a car accident and their spouse contacts, and says, hey, he's
Right.
really hurt, who
But
makes the determination that he
But for
he
the-
or she is no longer able?
Right. But for the 21 days, this
Wait.
temporary, there's an acting mayor,
So
the
we're
president of the
automatic-
council.
Okay, so no matter what, 21 days, we have either the city administrator or whoever is gonna run the city until the secession plan
Until
starts.
3/8.
So under any condition, the 21 days will have elapsed, is that right?
That's what I think.
And the city administrator would be the acting mayor until that happens, until the 21 days
In the
have
event the
elapsed.
city council president is unable,
I'm total.
the vice president shall act. If
Yeah.
either president or vice president can't, then the city council elects somebody.
Yeah. I don't know
If
why.
it goes,
Well, I'm confused
Yeah, I don't know
now.
why we're talking about city administrator. We have a process, correct? We have the city council president in that.
Yeah, that's why I'm confused. I think it's still unclear what happens when
When he's
this
sick.
occurs.
As soon as the mayor can't perform his duties, or he or she, however that's determined.
Right.
We can debate and discuss the process of how that's determined.
Right.
As soon as it is, though,
Right.
the city council president
Would-
steps in.
Yes, correct.
Yes.
That's the line of succession.
Correct.
That's the chain of command.
Yep.
Yeah.
I think what we're, maybe I use the poor choice of words, really, but we are getting bogged down to a degree on what that looks like. What constitutes he or she not being able to perform the duty? But.
I don't think it's what, I think it's who is determining,
And how it
Yeah.
happens.
and how is it determined?
Well, it certainly shouldn't be the city council. If anybody, look at it like a cabinet. As a matter of fact, there's been some mayors that have had a cabinet-style government, and I would argue right now, if I had to designate somebody to make that determination, I would say it would be the department heads would come together along maybe with the city administrator and the corporation council, I don't know, but certainly not the city council.
Renee, can you read your motion? Where
I think I'm gonna, you know
where are
what?
you putting that 21 day?
I think I'm gonna rescind that motion. I'm gonna tell you, I'm reading it, and I read it wrong. The president of the city council just takes over when he's sick. I mean, do we need a time frame?
That's what I was trying to,
Right, that's what I'm saying, like, why, that's where I was getting confused.
Well, I would
I'm gonna
suggest
say
yes.
yes,
I would
I
suggest you
say
do need a
yes.
time
Yes.
frame, and here's why. Because we've had in the past, I believe, maybe I'm wrong, we found out the mayor was on vacation in France. And then next thing you
Yes.
know, president of the city council was sitting in the mayor's chair. as if there was some pertinent business that they need to be in that chair for.
If they were gone for a
If
week.
if the mayor leaves the office at noon on a Friday, do you
So
want
if
the,
he-
the city
I
council
get-
president
I
sitting
hear
in the
ya.
chair?
You're
right with the
No, you know
20.
something?
agree.
I
You
don't
have to
want him
take the
sitting
I
there.
know,
politics-
Joe, I was gonna say, please.
You're
But
right.
you-
So my point is,
So
you
we
have
let
to
him
take
be
the
sick for
politics.
21
You
days.
have to take the politics out of it
Right.
as
Yes.
best as you can.
Right.
I think
So
we gotta
You let him
remove-
be sick for
This
21
is
days.
about managing the city, not managing politics.
Right.
Yes.
Well,
So
because
you let him be sick for
the
21
president of the
days.
city council will, as long as
On
they're
the
not unable.
22nd days, the president of the city council takes over. So he can be sick for 21 days.
Yes.
On the 22nd day, the
It was
president
this-
of the city council takes over.
Yep.
And nobody's deciding whether he can perform his duties or not. Nobody's deciding whether he's permanently vacant. Just on the 22nd day,
I personally don't see a problem with the way it runs right now, but that's me as one vote.
What happens when the mayor is out right now? The
Well,
city
that could be-
administrator steps in?
Under the charter, the city council
Well,
No,
I
I mean. in
Most of it's like
a
any other
day.
business. If your CFO was gone, you you just carry on. Everybody knows how to do their jobs. You carry on. And if there's an extremely important signature, you figure either way to get the mayor's signature, or you figure out a legal way to have somebody sign on behalf.
yeah, no, you know what, I'm not gonna rescind that
But
because I think.
but can you read where you're putting it?
I'm
I'm
gonna
just
put
not
it,
clear
so
where
whenever
you're
by
putting it.
reason of sickness or other cause, the mayor is unable to perform the duties of his office for longer than 21 days.
Okay.
The president of the city council shall be the acting mayor unless he's unable, because we've already stricken
Yeah.
unwilling to serve. In such instance, the provisions of 3(8)(c) shall apply.
Bang,
And-
take out.
and-
Are we gonna strike?
And I'm
the-
with you.
Strike
I'll
it.
go on and I'll make the motion to strike the city council by the affirmative
Yes.
vote.
Can we vote on the 21 days?
Want to vote on the
Yes,
21 days
yes,
first? Make it two motions?
Yeah.
Laura,
I
did you
seconded
second it?
I seconded
Okay,
it.
so the motion on the table is that this reads this way. Whenever by reason of sickness
I want to vote on one thing.
or other cause, the mayor is unable to perform the duties of the office over or past 21 days. Whatever is grammatically correct there.
Consecutive, please, add that in there.
Is it
For a
consecutive?
consecutive period.
Yeah.
I would prefer
For, right,
consecutive.
consecutive, yes, for consecutively 21 days. The president of the city council shall become the acting mayor unless the president of the council is unable to serve. In such instance, the provisions of 3(8)(c) shall apply, period.
Done, seconded.
That's the motion.
Seconded?
Could, want me to say it again?
No.
Yeah, you're right, it has to be consecutive 21
Consecutive
days.
period, yeah, 20 days. Yeah, we got that.
Take a vote.
So the 22nd day, that means that's when the president steps in.
Roll call?
Unless, of course, the mayor calls up and says, hey, I'm not
course.
coming in for a month or two. Then you don't have to worry
Yeah,
about
this is not
that.
even-
The
it's a
president's sitting in,
non-issue.
3(8)(c) kicks in, and then we're on to permanent
And
vacancy,
it probably
if
will
it's
be
that
more than
bad.
likely that happening, right? Because if you're really that sick, someone's gonna know and they're gonna
Correct,
say, hey,
correct.
I'm in a coma, he's in a coma, she's in a
Right.
coma.
And
Obviously,
we can define other cause later.
Do we take a roll call on that, President, Madam President, Council?
Yes, so, is there any more discussion, though, before we put it to a vote? And a roll call vote?
This is just on 21 days, right?
Just
Yes.
on 21A, the first sentence.
Okay,
Just the first sentence. Want me to read it again?
no,
No.
I'm good.
Yep,
All right,
we're
well,
good.
roll call vote, please. There was a request for a roll call
Yes.
vote.
Yes.
Yes.
Yes,
Yes.
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 vote passes unanimously.
Nice.
Do you want me to read that again? You got it, right?
He's good.
And
I got it,
you
yep.
guys get the grammar?
Yep.
Okay.
Yeah,
Number
we'll-
two.
we'll-
Second
we'll toss it up.
sentence is the city council, by the affirmative vote of 7 members, shall determine whether the mayor is unable to perform the duties of the office. The votes shall be taken in public session by a roll call vote.
Motion to strike the entire section.
Second.
Any discussion?
No.
Roll call.
Roll call. We'll start to the right.
Well, just, the entire section should just read, to be clear, correct?
Yeah.
Okay.
Yes,
Well,
not the
last
first
two
sentence,
sentences.
the last two sentences.
Thank you.
Yes.
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 Yes?
Yes.
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 Okay, motion passes to strike that complete last portion. Section 3(8)(b), I didn't think there was any issues with it, but I'm only one person, and that is powers of the acting mayor. The acting mayor shall have only those powers of the mayor that are indispensable and essential to conduct the business of the city in an orderly and efficient manner, and on which action may not be delayed. The acting mayor shall have no authority to make a permanent appointment or removal from city service unless the disability or absence of the mayor shall extend beyond 60 days,
That's
nor
what I said earlier.
Yes,
shall the acting mayor approve or disapprove of any measure adopted by the city council unless the time with the mayor would act would expire before the return of the mayor. City council president or any other councilor who may be serving as acting mayor pursuant to 38C shall not act as a member of the school committee, city council, I'm sorry.
He could,
City council,
he or she couldn't anyway, once
Right.
they're acting
mayor, they're mayor.
They don't partake
Right.
as a member of the
Madam Chair,
Yes,
I just, as my colleague pointed out to my right, that's where you got that disability
That's where that
language
came from.
You didn't make it up on your own, it's in the
okay.
charter,
I
okay?
feel bad though, because.
Yeah, it's in the charter, that
offensive.
language
Bad
is
language
there.
that is in there, but
All
wasn't
right.
in.
I
Thank
want
you.
a point of clarity though, that 60 days, is that from the time, because we just added 21
Does
days.
it include
We-
the 21 days?
Is it part of the
No.
21
No.
days or after
If
21?
his
So that's a,
absence exceeds
the president-
60 days in total.
Right, the president doesn't become the acting mayor until the 22nd day.
right.
22nd day, that's the council president's first day in office.
60 days of ticking.
So he would have 60 days from that 22nd
So if the mayor is
day.
technically out for 81 days, 82 days, is that what we're,
Well, he would be out after 21.
okay. Well, you're saying 60 days cannot approve,
After 60 days, his power to appoint and do other things changes.
yes.
I know what you're saying, though. Is it 60 days from the time he takes the seat?
Or is it 60 days from the time that the
Right.
mayor was at capacity?
I read it from the time he takes a seat.
Yeah, it says the acting mayor.
Okay,
So the
Just wanna
first,
clarify.
so it's the acting, and the person wouldn't become acting mayor until the 22nd day.
okay, okay.
Or if the mayor calls up and says, I'm not coming in anymore, then he's acting mayor from the day the mayor says, hey, I'm not making it to work for the next 6 months.
Okay.
Then he becomes the acting mayor on day 5,
Okay.
So that was
right,
my
of the
question
21
before,
day.
Is that, will we have to wait the full 21 days?
No, if a mayor calls up and says, I'm just talking about if a mayor
A
says, hey,
voluntary withdrawal?
yes, yes.
So it starts on the day of the voluntary
Voluntary
withdrawal?
withdrawal.
Or
Expiration
after
of the
21
22nd
days
days.
have expired,
Yes.
right? Okay, so that, I wonder if that should be included.
That when the acting mayor starts,
Or
Right.
that 60-day
Maybe
time
one
clock, because that's
extra-
important, right? If
one
they're gonna
extra
start
line.
appointing department heads
Especially if
or,
you're using that to establish the 60 days.
right.
There might be.
Just a point of clarity, I
be an
don't,
extra
the
line.
acting mayor shall have no authority to make a permanent appointment or remove from the city unless the disability or absence of the mayor shall extend,
Well, we already defined acting mayor doesn't happen
The-
until 21 days, or,
shall extend beyond 60
Acting,
days.
well, if
nor
after
shall
5
acting
days they
mayor
become
approve
acting
or-
mayor.
yeah.
You know, we can.
If I can just point out to the committee, that one of the suggestions by the public, 3.8 covers this, so if our clerk or anybody needs assistance in how to get the writing, it looks like there was some research done on this. It's at least worth looking at when we finalize it.
That's gonna be attached as Exhibit A to this week's minutes.
Right.
what section is it?
3.8,
Oh, gotcha.
Is this from Mr. Venice?
Yeah.
yeah.
Thank you, sir.
What one were you looking at, the,
The red?
oh, the B? Which one?
No, this one.
Which one are we looking at?
Temporary
This one.
absence.
C, it's A,
Temporary
it's
absence of
3
Just so the
C.
record is clear, the Charter Review Committee received public comment in the form of typed documents from Mr. Venice. Mr. Venice submitted public comment orally and in writing. And those public comment documents will be provided on the city website no later than 3 PM tomorrow, because we received them at 5 o'clock tonight. So we're referring to a document submitted by public comment, and it's the one on the top that says Section 8, temporary absence. Is that the one the committee is referring to?
Correct.
Okay. And what are we referring to?
Oh, I was just pointing out because, well, Mr. Venice wanted me to point out that this is, if we're stuck on language, that this is pertinent to what we're discussing right now. I wasn't taking a position for or against it, but just making sure we all knew it was out there.
Thank you.
Well, there is something in section A that's a little more clear with how the mayor is supposed to, let someone know that, the mayor shall, by letter filed with the city council and a copy filed with the city clerk, say I am incapacitated, so certainly we could consider adding that or not. I don't know if it's necessary, but that's a little more clarity for section A. But with B,
Well, this says that the mayor can designate a qualified city officer, city employee, and that the city council president would not step into that.
Yes.
I have
And
to
I don't-
tell you, though, as chair, I'm reluctant to discuss any of these documents until the public has them, okay? So,
fair enough.
if we could not refer to these anymore tonight
Sure.
until that they're published on the city website. They have to be in, by a certain time, and they weren't. So, just for future reference, if we can get them in earlier, but we can't discuss the, yeah. If they, I'll give you my email, and if you email them to me or Alan, we'll make sure they go to the city clerk for publication, either with the agenda.
Is it the day before?
Because if we're using
48 hours,
them
48 hours.
and we're referring to them and they're not available to the public, it could cause an issue, yes. So we can't refer to them. We've got to move on. And we can revisit, I just want to make the committee aware of this. We're talking about these sections, we're making some changes. We're going to have a couple drafts before we're done. We can go back.
Right.
But the clock is ticking,
Sure.
so.
I think we're good with.
38B is fine, 38C. I didn't have anything in my notes that we had issues with that last time. The agenda has us vacancy of the mayor. Is there anything in here, anybody, you know what the issue was at this? And I'm gonna make a motion to table it again. I was supposed to get somebody from the elections office to come down here to find out what would be the process. Because Fall River is a preliminary election. We have a preliminary election and a regular election. And does the special have a preliminary, and can you do it in a time frame?
Yes, the special has a preliminary.
Yes.
Right, but can they do it in this time frame?
I don't know, that's a question for election.
Right, so I'm gonna make a motion that we table 310 one more time till next week, and I will absolutely reach out to elections, and if I have to have Mr. Lyons come down and explain that to us, but that was the issue that we were gonna address in
second
that
that.
this week.
Yeah.
Can I get a second?
You mean table to
Okay.
next month,
Table it to the next meeting, which is,
17th.
something, April 17th, right? Is that all right? Any more discussion about tabling it?
Nope.
And if you'd
And-
like, I can assist with that. I'm on the election commission.
Oh, that's
So-
perfect then, yeah, grab Mr. Lyons
Yeah, I
and
can take
figure
care
out
of
how that special election works in the time frame of 310.
Okay.
Because that was our question, did it work in the time frame?
Yeah, just for the record, a motion to table, you get a motion, you get a second, and then there's no further discussion on a motion to table.
Any more, can we have a vote, please?
Yes,
Yes,
Yes.
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 Okay, motion passes 310 after discussions with elections. We'll go to next week. The next one is 4-3, prohibitions. And we addressed prohibitions for the city councilors, and we changed, we talked about prohibitions in 2-3.
Madam Chair.
Yes,
Even though I opposed it in 2-3 for purposes of language, I think we should just mimic what we did in
2-3
and insert it here.
okay.
is that a motion? I'll
Is that a
second it.
motion?
It is.
I'll second
that.
it.
Go for
Go, Paul. All in favor?
No.
The motion is that in 4.3 prohibitions, the motion is to mimic the language that this committee adopted by motion
For the city council.
for the city council, but for the language of the body it's talking about in 2.3.
Yeah,
All in favor?
no,
It's your motion.
He's
but I
got,
oppose,
Oh, okay, all right.
but I oppose the
I got you.
provision on the other side.
I got you.
Yes,
Yes.
To mimic,
Yes.
hold it, to
I
mimic the
get you.
language, yes.
To mimic the
Yeah,
language.
mimic the language.
That's what I'm
To
asking.
mimic the language, I vote yes.
To mimic the language of the
Two
changes.
Yes.
Yeah.
Okay,
When
I
we
got
get to
you.
the section, I'm gonna vote no, but
I got you. All in favor?
I.
Aye.
hi.
All right, motion passes unanimously. That's section 4.3 prohibitions. The language shall mimic the language we adopted in section 2.3 provisions. Moving on to 6.5. And I put these on the agenda because I get comments, so I put them on the agenda as the comments come. And 6.5 capital improvement program, I'm only gonna read the area that somebody sent me a comment on. A submission, the mayor shall submit a capital improvement program to the city council at least 180 days before the start of each fiscal year. The capital, and the comment was 180 days. Could that time be less?
180 days from what, though, eh?
Fiscal.
From before the start of the fiscal year, so the fiscal year is
June 1st to
July.
July.
July 1 to June 30th.
Right. And so they go 180 days backwards, 30, 60, 90, 30, that's 6 months.
Working now,
Just Jen,
Right.
yeah.
not problematic now.
I don't see. an issue with
Anybody?
that.
Okay, moving on.
If it ain't broke, don't fix it.
7-2. Seven two, preliminary election procedures, small a, signature requirements. The number of signatures of voters required to place the name of a candidate on the official ballot to be used at a preliminary election shall be as follows. For the office of mayor, not less than 300 certified signatures. For councilor at large or school committee member, not less than 150 certified signatures. Signatures of voters shall be made on a form prescribed by the Board of Election Commissioners and shall be made available not earlier than April 2nd in each preliminary election years, and those forms shall be submitted to the Board of Election Commissioners for certification of the names on or before the 14th day preceding the date fixed for submission to the city clerk. The form shall be submitted to the city clerk on or before 5 o'clock in the afternoon on the 45th day prior to the declared date of the preliminary election. An individual may appear on the ballot for only one office at any preliminary, regular, or special city election.
Madam Chair,
Please.
thank you very much. Two things. First of all, whether it's a preliminary or a general election, the signature requirements are the same for all elections. I thought I heard you read something different, maybe not, if I'm wrong, I
It's
apologize.
just different for
But-
the office.
It is, but I misunderstood what she read, but I know what I want to do.
But, this just said preliminary election procedures, because that's the title of
Okay,
it.
but I want to move that we change the signature requirements for the, I want to move that for the office of mayor, we go from 300 back to 50, what it was in the prior charter. For the office of city council, from 150 back to 50, and for the office of school committee, from 150 back to 50, to be eligible to get on the ballot.
I'll second that motion.
Can I just ask for?
Can I have further discussion?
Yeah.
Yeah,
like
I'd
it.
just kind of like to know your
I'm
reasoning.
gonna stop to my right. Go ahead, Kathy.
Can you just explain your reasoning for the
Absolutely,
change?
that's what I was gonna do, that's why I asked for further discussion after I got a second. It's very simple. I opposed, when there was a movement on the last Charter Commission, to increase the signature by 6 times from the prior charter. It was 50, we went from 50 to 300. For mayor, that's a 6-time increase. It's a 3-time increase for the office of city council and school committee. Number one, I think ballot access should be easy. And regardless of what the signature requirements are, I know that Councilor Washington has been on the ballot. I've been on the ballot. I don't know who else, if anyone here, has been on the ballot. But regardless of what the signature requirements are, you always need to get more than the required number, because you're always gonna have signatures that are gonna be disqualified by the elections office. Ballot access should be easy. Once you get on the ballot, that's where the work of running for office and running a campaign and meeting the public and putting your positions out and your vision for why you should be elected. That's where the real work of a campaign begins. Obtaining ballot access should be very easy. And once you get on the ballot, then the voters then decide collectively as a body whether you're worthy of moving on and being elected. And there were some of the reasons that were given in the last Charter Commission for increasing the numbers to have more qualified candidates who, I think anybody should have a right to run for office and put their ideas and their platforms out, and then people decide. Ballot access should be easy. Once you get on the ballot, then the real work of the campaign begins. Another thing that I find rather amusing, if you run for state representative, okay, you're only required to get 100 signatures. Okay, if you're a state rep, you represent the whole state of Massachusetts, which is comprised of 352 cities and towns. You need 100 signatures to represent every voter in the Commonwealth of Massachusetts. Here, to run for the city council, you need 150, more than the state level. That's ridiculous. Absolutely ridiculous.
I agree. I wish we could slide this in.
Kathy, does,
I mean, I now I understand the background. I mean, I personally think 50 is not enough. That's what I'm saying. Is there a number somewhere between 50 and 300?
I'm gonna say to you with all due respect, what I said to Councilor Washington last week. I made a motion, there's a second, we're having discussion. If there's an amendment, that's a separate vote. But I like 50, 50 worked for years and years. Then there was some laborious discovery by the infinite wisdom of the majority of my colleagues on the last Charter Commission that they moved to change it. Okay, I think those numbers were a disaster then. I think they're a disaster now. I'm making a motion to move it.
so the motion is 50, it's been seconded. Would you like to, any more discussion? No?
I like to discuss.
What's your discussion? Do you have some discussion, Laura? Because I got Alan too.
You go.
Mine's quick, I
Go
hope.
ahead, you go.
No, I
I
guess,
yield to
I
you.
hear what you're saying, and honestly, I haven't put a whole lot of thought into it, but what you're saying, I don't know why you'd even vote for 50, because what you're saying is you think it should be 0. And,
it
but
can't be
and the
zero.
strongest argument I heard from you was either maybe 0 or maybe 100 to be consistent with the state. So I guess I want to hear from people who probably have a lot more experience than I
I'm
do.
telling you right now.
If they believe it should be 0 or 100
I'm telling you.
or higher, and why.
I'm telling you right now, my motion is 50.
It's
I understand that, I'm just,
Get it?
You're
but-
just
We're just
discussing.
discussing.
my point of discussion was simply your argument, a strong argument, but was essentially it should be 0. That anybody should get on the ballot.
It can't be 0.
That's not what I said. I said ballot access should be easy. I didn't say 0.
Okay, so,
Please don't
Okay.
put words in my mouth.
Yeah.
fine, I'll
You
talk
said
over here.
50,
My
and I
discussion is
understood-
simply, if we have a requirement, what is the purpose? I'm trying not to be fixated on a number.
Yeah.
If there is a requirement, what is the purpose of the requirement? If the purpose of the requirement is to make sure somebody puts forth a minimal amount of effort and to show that there's a minimum amount of backing,
That's it.
then we should be talking about what that number is. And to leave it at what, the purpose of it. And
50 worked for years.
I don't know if,
Long before you got here, 50 was, what was the number for years, for decades. Nobody had a problem with it. I want to go back to 50.
All right,
So-
motion, there's some discussion. Ms. Washington, do you have further discussion on this motion
I
for
want
50?
to, here's what I feel. It is, to me, it's a pain. I did it. I don't think it matters if it's 50 signatures or 150 signatures. You're either gonna stand outside Market Basket for 6 hours or 18 hours. I mean, getting signatures.
Not to
like
be endorsed in Market
Market
Basket,
Basket,
let's let the
Walmart,
record
Shores,
reflect.
let's get them all in there.
We appreciate all grocery
The new
stores.
Dow Market, they're great. So, I mean, it to me, I like it to be 0 signatures, frankly, but I get it. So it really doesn't matter. I think you're right. In seat 1, that the real campaigning starts after you collect the signatures. So to me, it doesn't matter. I will support your 50 signatures. I will support 150. I just think it doesn't matter. Other than it's a pain to get.
The only reason I chose 50 is because that was in the prior
That's what it
charter.
was.
It was in the prior charter, and no one had an issue with it until we got to the last charter commission. Then suddenly there was this grave movement to increase the numbers 6 times from there.
All right.
okay, but what
So-
you're saying is nobody had an issue until the issue was brought up.
Right.
I mean,
By
That's what I'm
the
not clear on.
consultant
I'm not
and
clear
the
on.
majority of the last.
okay, I'm not putting words in your mouth, but those are your words.
Yeah,
Nobody had an issue
The
until we had to
motion-
discuss the issue, and then they had an issue.
Right.
Which to me, there was an issue.
Right, I think there's more to it than just to ensure qualified
Well,
candidates, or was there more, is there a
This-
history? What's the history?
There were, listen, there were oftentimes a vast array of candidates from all walks of life. And when it became 300, that was a lot for a lot of people from all walks of life. And I concur with my vice chair. I don't think it should be 0. I think there should be initially some work to show interest in running for office. 50 is what it always was. I think that, and I don't care, an 18-year-old, I would hope that an 18-year-old graduating from Durfee High School decides to get that involved, and all he'll need is 50, which is,
Absolutely.
how many on a sheet? 20 on a sheet. I think it's 3 sheets, right? I also was never in favor of the increase in numbers, because now the people on the ballot are half of what there used to be. And it was interesting to see, they would call for debates and have different people from all walks of life. Masters, Juris Doctorates, high school diplomas, GEDs, or none. All levels of education, all levels of everything used to run for offices. And I don't know if it became the number of signatures you have to get. But I know, watching the past few elections, there are less people that are running. Is it because of the signatures they have to get? I don't know, I didn't do a study.
No.
But I know that part of it is, there was a lot more people that ran.
I think Tim has.
Well, I have some thoughts.
But, I want to
If-
remind you, you're on the elections committee, so.
Yes,
I
yes.
don't
So
know
I won't
about-
say too much,
Right.
other than if we're gonna make a change, I think the change should be consistent with how it's done in the state.
Yes.
So, that way there's no confusion. The reason we chose this, regardless of opinion, is because the state is doing it this way, and so we wanna be consistent with that. I don't necessarily agree or disagree with some of the things that have been discussed, but I think if we take an approach like that, it kind of makes us neutral. And I do understand that there were reasons for this to have been discussed in the last charter, and there was a reason for it to be raised. So going back to the way we were is kind of counterproductive, and I think also whatever reasoning that was, I wasn't part of that charter subcommittee, so I can't say, but certainly there was a reason for that discussion, and there was a reason for that change.
I
So-
attempted to lay out the reasons why that body, and whether anybody wants to believe this or not, the consultant played a heavy role in a lot of the topics and how they were framed. I was there, I sat through 27 to 35 meetings in a year and a half. Believe me, it was painstaking.
Madam Chair.
So this is a real picnic for you. Dan, so there's a motion on the table, and the motion is for just the, for the very first sentence, it's two, because I want to address just something later in that paragraph, signature requirements. The motion is, and correct me if I'm wrong, Dan, the number of signatures of voters required to place the name of a candidate on the official ballot to be used at a preliminary election shall be as follows. For the office of mayor, not less than 50 certified signature. For councilor at large or school committee, not less than 50 certified signatures, period.
That's my motion.
Can I ask a question?
Yes.
I know that, but, so to
Did
take in,
we got a second, correct?
we
There
Yeah,
is a
we're-
second.
Ask all the questions you want.
take into account what Tim said, would we consider amending that to be 100 signatures to be consistent with what is in the state? Across the board for mayor and for city councilor?
No, I won't consider amending it at this time because I was opposed to moving the numbers in the first charter. I like these numbers work well. People didn't even know what the numbers were on the state level.
But she can make a motion to amend yours.
She's asking me if I'd second.
If you would
No,
consider.
I was asking
She
if
would
you
make
would
a-
consider amending your motion to be 100.
I won't consider amending it. That doesn't mean someone else won't amend it. I won't amend it because I want 50.
Okay. Well, I want
I just, one quick point of discussion, and I'm not saying this is the overriding factor, but I at least want the board before they vote to understand that one factor is money. And what I mean by that is if you have a candidate on the ballot who really is not a serious candidate, that somehow creates a preliminary election. Each election, I can't even quote, you probably know better than I do. It's not cheap.
It's a
I
lot.
want to say about 60, that sounds about right, but don't quote me on that, somewhere around $60,000. And, you know,
And
I'm
the
not
more
sure
we
what the
go
number should be,
ballots-
but I know it would be a shame for the city to waste $60,000 because one person had to get, you know, a too low of a number of signatures,
Well,
so
the
he's not a
issue, too,
serious
is the more
candidate.
people on the ballot, the more ballots we have to print, which is another big expense, right?
Yeah.
Because as you continue to add people, if they can, like, if it was zero,
Yeah.
and everyone could go and get on the ballot, and we have 2-3 pages of ballots at this point, you know, that's huge expense for the
Yeah.
city.
And I wouldn't necessarily be bound by what the
I'm sorry,
state is
I don't
because
think-
we're Fall River, but if we don't have a reason to be different, it does make sense to be consistent. If we have a strong reason why we want to be different, of course, let's be different. But that's just my 2 cents.
I know money's a factor, but I don't think finances should ever interfere with democracy.
That's not what I said.
But,
That's not what I said.
no, but.
I mean, if it were one signature, you know, if you just needed one signature, you know, you get your significant
Mr.
other, sign
I'm
away.
sorry, Danny, hang one second. Laura's been waiting patiently.
I'm gonna go with what my colleague in seat 1 said last week. If it's good for Washington, if it's good for the state, then it's good for us. So I think the 100 to be consecutive across the board is okay, so I don't know when it's proper for me to second her
that's what
motion.
I didn't make,
So,
that's
well,
what I'm
she didn't
saying.
make a
anything.
motion
Well, that's what
yet.
I'm
There's
saying.
no
Do I
motion
need
to
to make-
amend on the table. It's just the original
Okay.
motion, and that's been seconded.
Okay, so does that need to get voted on first, or can I make a motion to amend?
You have to vote on his.
You
vote on this.
Vote on
his.
his, and then you can amend, and then we
Okay.
vote on yours.
Okay,
If his doesn't.
if his
pass.
doesn't pass.
Correct.
Right, yes.
Is there any further discussion on Dan's motion?
No.
Would you like a roll call vote?
Yes,
We'll start with you.
yes.
No,
No.
Yes.
No.
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 Okay, motion does not pass.
I'd like to make a motion to amend section 7.2 to be 100 certified signatures for both the mayor, the counselor at large, or school committee member, to be consistent with state requirements.
I'll second your.
Motion made by Kathy that the first sentence reads, "The number of signatures for voters required to place the name of a candidate on the official ballot to be used at a preliminary election shall be as follows. The office of mayor not less than 100 certified signatures for a counselor, at large school committee member not less than 100 certified signatures." Seconded by Laura Washington. Any further discussion?
Discussion? Very briefly. These are not the numbers I like, but it's a decrease, so I will support it.
Okay.
I yield.
Are we ready to?
Quick discussion, just I would not put because it's consistent with state language in there. Because if the state were to change,
Oh,
then
I
people
didn't-
come
I
after
didn't-
attack. I know, I
It was
want to
the
make
state
sure.
language.
No, but
I agree.
I
I didn't
hadn't
hear
said
it.
that. but-
Did you say it? But I
Yeah.
didn't.
Right.
Right, just
Okay.
because if the
No
state
state
language.
language
makes
is-
sense.
Okay. Roll call vote? Are all in favor?
I changed my mind.
I'm
No,
gonna abstain.
Roll call vote, starting with Dan.
no.
Paul?
yes,
I'm gonna abstain.
Yes.
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 Motion passes. I want to address just one other issue in this paragraph, because, and I don't know if we have to get somebody from elections, but it doesn't make sense to me. The signatures of the voters on the form created by the Board of Election Commissioners are available by April 2nd, preliminary year. The forms are submitted to the Board of Election Commissioners for certification, and then they go back to the clerk for no good reason. I don't know if it's to date or stamp, but I don't know why the city clerk gets them. I don't think it's necessary, because then the Board of Elections certify, the forms go out. The candidate picks up the forms. They take the forms, they go out in the community, they sign them, address, right? They come back to the Board of Elections. The Board of Elections goes through every signature and certifies them. Then those certifieds go down to the clerk's office for no good reason, I don't know. And then they go back upstairs to the Board of Elections. And then the ballots are made and then we have the election. There is absolutely no good reason, I did speak to somebody at elections, and there's no good reason why they go to city clerks. Now, I don't know if it's to make sure, because the next sentence says the forms have to be submitted by 5 o'clock. Why can't the forms be submitted back to the elections office by 5 o'clock? Why is it the city clerk? I think the city clerk should be completely out of the elections. She's not an election official, she's not prescribed on any electoral duties in our charter or in our ordinances. And I don't think it makes sense to have it in there because it's not necessary. Ooh, that's a good one. It's just a discussion, I didn't make a motion, but that's what I'm thinking.
Maybe you know, but my only thought when you said that was because there's a term, I'm just drawing a blank, but she's in charge of public records. The clerk is in charge of public records.
Recording, that's
It's
what I
probably just to create the public
is.
record. They put copies down
As far
there.
as I know, it's just for that
But
purpose.
why can't the election office make copies
Well,
of
because when you
them and
pull
give
your,
to
when you pull papers, you have to pull it from the city council's office, city clerk's office, and then they give you the paperwork.
This is an election, we have a board of electors, I just don't know why it's done that way, and.
I'm not
maybe-
sure, I don't know either. I'm just, that was my
I'm
only
gonna-
thought.
I can't answer that either, but I do know that it's, more than likely, it's for record reasons. Because we do all of that work, the stamping, the reviewing and all that stuff, and then so.
Then I would, we're gonna revisit that after we get some answers from the elections office, because I was just, that's why there's not a motion, I just was wondering why. And 8:05, what time is it, first of all?
It's 20 of,
39.
Sorry, what is it, 20 of what?
20 of 7.
We're only gonna have 20 minutes of this. discussion on the roll, let me make some observations. Section 8.5 recall was challenged. And if the clerk, Paul, if you would please remind the committee exactly what happened in court regarding recall. I know you did last time, you gave us the notes, but if you could make the record clear, we're talking about section 8.5 recall. Section A is application, B is recall petition, C is recall election, D, recall of one or more office holders, E, office holder, F, recall ballots. So, I believe there's a couple issues this. F, the recall ballot, if you could, and was it just the recall ballot? Was the lawsuit about the recall ballot? So, just referring everybody to recall section 8-5. We're gonna go to F, the recall ballots, because that's what the lawsuit was about, right?
Well, the lawsuit also implied that voters were disenfranchised because the recall was, the voters, the majority of voters voted to recall the former mayor.
And then he was reelected on the bottom because of a split vote?
That's correct. There were, I believe, 6 candidates. So the number of voters who voted to re-elect him was half of what the voters who voted to recall him. So one of the things that I argued was that the voters who voted for the recall were disenfranchised. And basically, the decision of Judge Perino was that, and perhaps this was a mistake because what I did was I submitted affidavits in support of our complaint, one from the prior chair, Mike Mioza, and one from Mrs. Venice, who was the clerk. And talked about how much work they put into the charter, mentioning that it was 27 meetings, that there were 3 public meetings. And basically what the judge said was that, so what happened was that the charter suspended or overruled prior language, which specifically allowed for the recall office holder to be reelected. So the charter's new language eliminated that. But what the judge ultimately found, and he said, well, they spent a great deal of time discussing this charter.
But we didn't put in the language
But
prohibiting him
that's correct.
from running after being recalled.
So the language to prohibit running for re-election within the recall election was not there. And so he basically said they spent so much time and that's absent. So
So we have
You
to
know.
add it in right now.
So
That's
the
correct.
only thing that needs to be, well, I shouldn't say it like that. I'm gonna strike all that. So it appears that the biggest issue with section 8.5, the recall portion of the charter, is that it doesn't have a provision preventing somebody who has been recalled from appearing on a ballot either in that special election or even that year's regular election. Because, you know, we have to,
Go ahead. I
Yes.
just want to be in line.
right, so,
I want to have
Right.
a contrarian opinion before everybody makes their mind up on
no,
this.
you can't.
And here's what I have to say about this. When this happened, I was probably just like everybody else. I was surprised that the recalled mayor could then rerun and then win. But with time, I started thinking about it, and I think that one of 2 things. I think actually Fall River got it right, and let me explain why. I think this section should not necessarily be a recall. We could maybe rename it something where it's not a recall. But my point is this: in politics, a 60-40 is a strong win. I mean, that's a dominating win if somebody runs for election and wins by 60%.
Be careful of your numbers, though.
Okay, whatever.
That is
Let's
not
all right.
accurate, though.
That's
It's
fine.
60-40 of less than a third of who voted in the
I
original
understand that,
election.
but I'm
so
telling you an election.
Don't go 60-40.
Okay, let me have my time.
Okay, I will.
historically, a 60-40 is a pretty dominant win. And what that means is that somebody who won election pretty convincingly had 40% of the people who voted against that person, okay? So we're talking about democracy or representative democracy and the voters' will and the voters' will. We've said that over and over again. But this section, we're trying to, potentially gonna change it, says that 5%, now I know it's registered voters, but 5% not only can call a new election, but can knock out the democratically elected politician. And I think it's wrong. I think if you wanna have 5% of the signatures, which is difficult to get, I'm not saying it is, but it's only 5%. No matter how popular, 5% probably hate you for whatever reason, okay? If you can get all of them to sign on, you're not even eligible to rerun. I think this section should be, that 5% allows a new election, and I think, you know what? Like it or not, that person won a majority of the votes in the re-election. I think there are other ways to do it. Maybe you could have another preliminary election, because the problem was.
Maybe you get
Hold on
rid
a
of
sec.
recall and have an impeachment process.
No.
But I think in that situation, Fall River typically has two people going head-to-head for mayor. Because you have a preliminary election if there's three or more, correct?
So
So in this case, you kind of, the problem was, I think the vote got watered down, like a certain percent are
Oh,
gonna vote
here's
for
what
the mayor
happened.
no matter
So-
what.
I'm sorry. So
No, my last point was simply, yes, when you have three or more, I will agree that whoever is in charge, whoever it is going to get a certain percentage because it's the way the business is going. Anybody who, so the more and more opposition you have, 3, 4, 5 people, is more likely that the city mayor is gonna get reelected.
So
I
you'd rather
grant
see a
that.
higher percentage
I
of
don't know,
registered voters?
I don't think 5% knocks out a mayor. I'm sorry. It's a democratically elected mayor.
Well, 5% to,
5% to initiate the
To-
election.
But you're saying that the possible amendment is that person can no longer rerun. So you're letting 5%
no,
knock out a
if
majority.
they are recalled,
They're only not allowed to rerun for one cycle.
yeah.
for one
And
cycle.
in that recall election, Mr. Carrera was recalled by 61% of the voters during that election. He was then
Okay, you're right.
reelected by 35.4% of the voters
That's what I
in
mean
that
by the
election.
numbers.
Yes, you're right, you're right, not that.
Which
But
means-
60% voted to recall.
That's
Right.
where
That's the piece.
That's the so.
So-
very
so
passionate
it's
about
not
this
to.
section.
So what
it's-
happened was that a little less than 50% of the people who voted to recall him were disenfranchised.
We're disenfranchised.
Well,
We don't
actually,
matter.
100% were
Right,
disenfranchised.
Right. So it isn't, so you gotta have, you either have to have impeachment or recall. Because you have to have a mechanism in your charter.
No, an impeachment would be, and that's difficult, but an impeachment would be done by, say, the city council. The recall is done by the voters.
But there's,
The whole process is voter initiated.
right. But I'm
And-
just saying
and
there
they
has to be a
obtained-
mechanism.
They obtained 7,500 signatures.
So yes, I remember. Listen,
But there
I
has to
was
be a
there for that.
mechanism to remove an elected official.
Count-
You
Well,
can't not.
that's
Okay,
that's
Council Chair.
separate from this discussion. What we talked about was that I was going to do some further research about impeachment procedures. We'll address that at a later
that's
point.
gonna be from
Right now,
No,
we're
no, I know.
talking about the recall.
So here's what I feel about that, to your point. I don't often disagree with you, but we may part ways here, okay? So you have a 5% to get on a ballot, okay? Is that what we're talking about? 5%, we gotta get on the ballot, 5%. But that doesn't mean you're going to be recalled. That means that you now get a chance to vote. So you may get on the ballot, but you may still win, but the majority of the people can vote you out. So you know what, hey, 5% of the people don't like me, here's your shot, it is what it is, that's the process. And now I have to campaign during my recall to try to stake my claim here that I shouldn't be recalled. That's just my personal opinion, that it is what it is. So 5%, 10%, but if you are recalled, you get on that ballot, and it is what it is. The numbers prove it. I mean,
Right.
that's how.
So we just need a
I yield.
prohibition to appear on the ballot. That's what the court was saying. Is
I
that you guys
amended-
don't have a
I
prohibition,
amended.
he gets on
Yeah.
it.
I amended and added, this is the section that I added, The subject of the recall election is not eligible to be reelected during a recall election. The name of the subject of the recall shall not appear as a candidate on the second prong of the ballot. If a majority of the voters vote to recall the office holder, he is removed from office.
The majority of the voters at that point, not 5%.
Correct.
Now,
have some public
5% just starts the process
Start- it starts
of
on-
a
yes.
recall election.
Starts the process, and then it's like a regular voting. At that
Yeah.
time, it's like a regular election.
Right,
Then it's
but,
a yes,
so
no
is
vote.
it,
So
but,
I move to
ordering that.
adopt this language.
Rainey, can I say
Second.
something, please?
Go
Or
ahead.
am I supposed to talk?
No, go ahead, Mr. Venice, please. I know this, you're passionate about this.
I make a motion to waive the rules for him.
Go ahead, thank you.
The way I read it, the first section of the recall is you have a vote. And if the incumbent loses that election, the position shall be declared vacant. Now, you have other provisions within the charter as to how to fill a vacancy. If you have an election, you're gonna be violating the charter by having an election and not filling the vacancy by the vacancy provisions of the charter.
You don't believe there
So
should be an
my-
election?
But the charter passed with this with the current recall section. in
That's
it.
correct.
Yeah.
Is
And
that
the
right?
court, and the court did not have any problems with the general recall provision. The only thing that he focused on was the specific, the specific language was not there saying that the subject of the recall could not be reelected.
Mr. Machado, is it your opinion, however, that the judge didn't go on to name that as an issue because they could stop there was no prohibition? And in future potential litigation, would that come up as an issue?
Well, one never knows what's going to be raised in future litigation, but I can say
That
that
wasn't the subject of the case.
But the decision of Judge, who was it? I'm forgetting who it was.
Magnolia.
No. The decision of the judge did not talk about any difficulties with the recall election in general, just the fact that he did not, that the statute, that the charter did not specifically say, use that language.
It is true, however, that the processes are inconsistent and compatible with one another.
I'm sorry?
How so?
The recall process and the vacancy they're incompatible. If the recall process is going to be different, is it a vacancy? Is the recall, if you recall a mayor, is that considered a vacancy?
Not if you're filling it at the same election.
Yeah, it's the same.
No, and the difference is, I think the primary difference is that the recall is a citizen, a voter initiated process.
I understand. Okay, so I see the difference.
So that gives the voters the right to say, we don't like
That
this
provides clarity
officer.
for me. That distinction makes it clear for me. Thank you.
And there's nothing in Judge Perini's decision where he talks about the fact that the recall process is inappropriate. What he talks about, what he talks about is that, I'm sorry, I was looking at the other case. What he talks about is the fact that the Charter Commission, in spite of all the time they spent, did not use that specific language.
We
And he
tried.
didn't make any reference to the fact that the recall election would be inappropriate in any other way.
How many mayors have been recalled in Fall River over a lot?
Two.
Two, right?
We had two?
So,
Oh,
right. So my point is, recall, not just in Fall River, but nationally, the idea of a recall, a do-over almost, has become more prominent. It's becoming more expensive. We have a mayor that currently, now this could change, of course, but it's 2 years. But we're moving towards this idea that our person wasn't elected, I can get 5%, and then you only need 51%, and then you move on. But I guess what I want everybody to think of, to remove an elected person, I think you need 5% or more if you want to raise it, a 51%, and then that person that you want out has to not win the majority of votes. I mean, are we really unhappy that through all that, the mayor that we want, that some people want to recall, still won the popular
No, it's
vote?
horrible, that's the system
No,
that's broken.
but that's, it's not.
Mr. Rumsey.
They won the most votes and stayed mayor. Is that a problem, really?
Mr. Rumsey, with all due respect, I respect you as the corporation counsel, but you're expressing an opinion here.
No,
That's beyond, not a legal opinion.
No, I don't, I respect his opinion, actually, and I do, but I respect it a lot, a matter of fact, but
But it's not a legal opinion, and that's his rule.
You're wrong.
You're-
And let me, if I may,
Yeah.
you're wrong. Because let's say, and we know that the judge did not necessarily affirmatively comment on this issue. But let's hypothetically assume that he did address it. You're gonna
But he
tell me,
didn't.
no, I'm gonna tell you this. If you have a judge who sits there and talks about a 5% recall method, and then a 51% vote, and then you have somebody take it to court and say, and I won the popular vote, but they wouldn't let me. I think the judge is gonna agree. You know what? That person is eligible. You're telling them that they're not even eligible to run. It's it should be an extremely high hurdle to take out an elected official.
So, but they don't get on the vote, because if you are recalled by the majority, then you are not gonna be able to the way I see it and would wanna see it, is that you are not gonna be able now to be on, to be voted on.
I get that, but what I'm saying is, but we know what happened in our situation. Right? We know what happened in our situation, and even though a majority of 51% of the people who voted that day
Yeah,
voted to recall, there was still a majority in favor of that mayor.
because it was a split, but
Yeah.
very, very.
It was a
majority.
split.
If we would have had a preliminary election to elect and to have a successor, then it would have been a one-to-one, and
Probably.
they would have lost.
Yes.
I will
Yes.
agree with you on that,
Yes.
So-
but we'll
That's
never
what we
know.
need
So
to
that's
discuss.
the issue,
Yeah.
I think, because it certainly, the
Not
mayor,
the
the sitting
rest of
mayor
it.
only got
We're
30%.
only talking about replacing the mayor after he or she is recalled, and their ability to run or not after
don't-
being recalled.
And with that said, Dan, it is 5 of 7, we're not going beyond 7 o'clock. Recall is gonna take another meeting, and much more time than we have left.
Can we hear
And
just a little bit here from the
we're not gonna
elections
vote,
office?
so please,
There's a
I don't,
motion and a second already on the floor.
I don't think there was a second.
there was no second.
What was the motion?
There was,
I'm curious
that
of what
was
the
the shot.
elections
Paul made a
official
motion, but
has
there
to
was
say
no
about
second.
this.
there was a second.
Well, so I will say this, I was not an election commissioner at that time, I came in after that.
All right.
I guess the question, it seems like the
Make
issue,
the same motion again at the next meeting.
it seems like the issue was that the mayor was recalled, he was able to run again. He was recalled on the ballot, but because there was too many candidates running against him, that there was way too many votes
It was
spreading out,
split.
not necessarily to him. So it seems like the issue is less all the other stuff as it is, how do we handle that in the future? Because I don't necessarily think that, and this is my own personal opinion, that even recalling the mayor, that he shouldn't have the right to run again, and if he gets the votes to run, he should. But we do need to kind of trim the field down if we're not gonna have this happen again in the future.
Next
And
meeting.
so I think
Is a recalled mayor making the office vacant, though? That's a.
that's a,
we are
that-
not
but
gonna settle
That's
this
a pretty good
before,
point. But
No,
that
we're
is a
not.
very
Ma-
valid point too, but nonetheless,
But
this is a different
Right.
process.
process, so,
Yeah, this is a
Paul,
different
was
type
your
of
motion
process.
seconded?
did I
Either me or
I
Laura
seconded it, I seconded his motion.
That was to table this to.
No,
next-
that was to adopt his
adopt the
language, which
language.
I fully support,
Which was
so.
what? I don't know.
The language that the subject of the recall is not eligible to be re-elected. The name of the subject of the recall shall not appear as a candidate.
We were
on the
discussing
second
after the
prong
second.
of the ballot.
And we were in discussion phase, so I don't
After
think we
the
can,
second.
I don't think we can take a vote, because we haven't fully discussed the
Right.
issue
So you
at
wanna
this
take-
time.
And I'm just gonna
Wait,
abstain
wait.
from that, just.
I mean,
Who made the motion?
Paul?
Is it possible you can withdraw it and would bring it back next meeting?
yeah,
Or table it, for,
Or
table it?
vote on it
for
and
more
then-
discussion.
I
So if
would
it's-
we're not gonna win
Until
the
we
votes anyway, so we'll
Raise
take,
this issue again.
yeah.
You withdraw your motion?
Yep.
So Paul withdraws his motion.
And I make a motion to adjourn the meeting.
Laura made a motion to adjourn. Can I have a second?
I'll second it.
Kathy seconds that motion. Would you like a roll call vote on an adjournment, or can we vote?
7 o'clock, 7
All in
o'clock.
favor?
Aye.
Okay. Thank you, everybody.